Carly Davis and Carly Hoosier. And this is 24 DCCR 1385 and 25 DCCR 1237. And so their state has, we were going to be here on reviewing bond conditions, correct? And then the state has filed a motion to increase the bond.
Yes, Judge.
And is that in both of the cases or just that one?
In both cases, Judge.
Let me pull this up. I know I took a look at it last week, but
This one's charged.
and so we've got both of these cases are driving while intoxicated, third or more. The first offense date is from May 6th of 2023. The second from February 10th of 2025. Give me just a second here. Well, it's working. It's just working slow. So I've got some history with regard to prescriptions. Some of it's obviously very hard to read, but it looks like prescriptions for alprazolam and something called D-amphetamine. Okay. Can't tell the date. One of them specifically says no refills. I can't read the dates on these.
We can get better photos, Judge. She had had that prescription for,
All right, it shows it expires October of this October 31st for the.
Judge, I had a number of questions about those photos myself. I mean, I'm not necessarily, well, I guess I am questioning the validity. This doctor that allegedly prescribed it, this Rajan Desai, in Austin address or a Millburn, Texas address for this doctor. When I looked him up through the Texas Medical Board, and I'm just a little curious about.
So where do you go to the doctor? Where's this doctor from?
From Beaumont, and I do a telemed every month because I go to his office now. I don't know what you're today now.
Today?
Yes, ma'am.
Where specifically?
Telemed today.
Oh,
Yes.
well, here's what I think I'm going to do based on the nature of what these medications are and the history. Well, are you driving?
No.
Okay, I don't know if I already did, but a condition of your bond is going to be, as of today, that you are not allowed to drive any vehicle ever, period. Okay, so if you're caught driving, obviously you'll be right back in jail without, probably without a bond. Mr. Coleman, other than a no driving, is there any other?
You know, Judge, I just would like to reiterate, and we put it in our motion. It sounds like the court's read the motion, but you know, she's got 4 previous DWIs, Judge, and in addition, she picked up this latest DWI while out on bond for a DWI,
Right.
Judge. And that, along with the positive drug test, I think the public safety, the community safety demands some additional assurances.
and Judge, our argument would be that the DWI itself is for the medications. She's been on these medications for.
Well, it doesn't matter if you're on medication and you're
Right.
taking too much medication, then that's a problem.
Sure.
So you can be on these medications and not be.
Also, the failure of the drug test was for these medications.
Right, I understand that. My biggest concern is the fact that if the if the medications are not being taken properly or too much of the medications, then that's a larger concern with the safety, and I completely understand and agree with Mr. Coleman on that. How'd you get here today? Here's what I want you to do, what I'm going to order you to do. I'm going to order that.
Here the judge makes a surprisingly compassionate move. Instead of sending Carly back to jail, she orders her to meet her doctor the same day to find non-narcotic alternatives. This is a fascinating glimpse into therapeutic justice. A modern approach where courts try to treat the root cause rather than just punish the outcome. But it's also a ticking clock. If Carly fails to provide proof today, she's back behind bars.
At your appointment, I'm requiring you to find out and with your doctor, get a prescription for something that is non-narcotic. So something that is not going to cause these issues if in fact our concern is that you are misusing or overusing these medications, then there's other medications that you can take. You need to talk to him today. I want you on your way to be off of both of these medications and on something that would not lead to the issues that you're having. Does that make sense? You need to get that information from him, find out what he can prescribe. I want those to Ms. DeLage, and I want her to get those to me. That is a condition of your bond at this point. If you don't do that today at that appointment and get that information to her, then I'm going to, what I'll do today is not rule on Mr. Coleman's motion. So that motion to raise your bond is still out there. And if you don't get this information and you don't get this done today, then your bond will likely be raised and you'll be in jail. Do you understand? All right.
My only question is the medication to get off of it abruptly can cause.
I understand that. I'm not saying you have to get off of it abruptly. I'm saying I want the plan and how you're going to do it, what it's going to be reduced to, what it's going to take its place, whatever it is. I want that. You need to tell him that you have been ordered to get off the medications, but obviously that needs to be done in a medical way, but I want whatever that plan is and how you're going to do that, and I want that to Ms. DeLay so she can get it to me tomorrow. Okay? All right, y'all are free to go.
Thank you, Your Honor.
All right, so you're James Lofton?
Yes, ma'am.
And Mr. Lofton was previously in court. Now, the misdemeanor is something that, remind me, why do I have that on?
He was supposed to have pled to his misdemeanor several resets
Right.
ago each time prior to coming down here because our plan is to have him, we had talked about
To extend
ISF,
probation and ISF.
But now it's for safety if the court considers based on this update PSI, but obviously we can't do that until he pleads to the misdemeanor.
Well, I can do that today, and he can go into custody, and y'all can go take care of it.
That's what I was just going to.
Because he'll sit in custody until he goes and
Correct,
takes
that's-
care of that other case, because he
that's
won't go.
correct.
All right. So in cause number 16-24485, first year James Lofton. Mr. Lofton was previously in court, and that is a motion to revoke probation. On probation for the third-degree felony of assault, family violence. It was a 5-year deferred.
A tense courtroom hearing unfolds as Judge Stephanie Boyd reviews multiple high-risk probation cases involving repeat DWI offenses, failed drug tests, and defendants already on thin ice with the justice system. From the very beginning, the judge makes it clear that public safety will come before excuses. The hearing first focuses on Carly Hooser, a woman facing serious concerns after picking up another DWI charge while already out on bond for a previous intoxication-related offense. Prosecutors reveal that Carly has multiple prior DWI cases and tested positive for prescription medications believed to impair her ability to drive safely. As attorneys debate the validity of her prescriptions and whether the medications were being misused, Judge Boyd shifts the entire hearing in a dramatic direction. Instead of immediately revoking bond and sending Carly back to jail, the judge offers one final opportunity to avoid incarceration. Judge Boyd orders Carly to immediately meet with her doctor and develop a medically supervised plan to transition off narcotic medications and onto safer alternatives. But the warning is severe. If she fails to provide proof of compliance by the next day, the state's motion to increase her bond could be granted, sending her straight back behind bars. The courtroom tension intensifies again when another defendant, James Lofton, appears before the bench on a motion to revoke probation tied to a felony assault family violence case. Court records reveal a long history of probation violations, substance abuse issues, and a recent DWI arrest while still under supervision. Although Lofton's attorney argues that he has stable employment and recent clean drug tests, probation officers reveal that he previously tested positive for methamphetamine and had disappeared from supervision for years. Judge Boyd carefully reviews updated evaluations recommending strict treatment and supervision if probation is allowed to continue. Then comes the moment that changes everything. Judge Boyd announces that she will allow Lofton to remain on probation, but under crushing new conditions. His probation is extended for 3 more years. He is ordered into an intensive SAFPF drug treatment program, placed on high-risk supervision, and required to wear a constant drug monitoring patch after release. But the judge's final warning sends a chill through the courtroom. Judge Boyd tells Lofton this is absolutely his last chance. One failed drug test, one violation, or one more arrest would immediately trigger the full 10-year prison sentence already hanging over his head, with no negotiations left. By the end of the hearing, Judge Stephanie Boyd makes her message painfully clear. Rehabilitation may still be possible, but only for defendants willing to follow every condition exactly. In her courtroom, second chances come with strict consequences, and final warnings are never empty threats.
I defer to the first discretion judge, just my review of the PSI. I think safety is probably well-being.
And so with regard to Ms. Jefferson, you initially also agreed that ISF with being on the high-risk caseload after would be appropriate. Is that your, what are your thoughts?
Yes, that was my initial recommendation. But I also included that I don't know much about his case because he had absconded for, I believe, over 2 years.
Yeah. And it looks like there was a tested positive for methamphetamine August 14th, last month, denied using it, but stated he had used a month ago, but tested positive for it. I'm trying to see what specifically, why special needs.
I don't believe there was any sort of psychiatric.
I didn't see that either, so I'm not real sure.
That was kind of what, the only question I had about it was.
I don't think we need.
Special needs is generally.
It is, if there's
more
some
of a
type.
psychological type situation.
We don't have that, so
No, we
it's just
don't.
regular. Okay, so here's what I'm going.
The verdict lands hard but fair. Lofton stays on probation, but with a 3-year extension, mandatory drug treatment in the SAFP program, and a drug patch monitoring system. Translation: one slip, just one, and he's doing the full 10-year term. The judge's warning isn't performative. It's a final shot at redemption, one that most defendants never get twice.
To do. Mr. Lofton, I am going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I am going to continue you on probation. I'm going to extend your probation period for 3 years. I'm going to order as a condition of your probation that you enter and successfully complete the SAFP program, not the special needs, but the regular SAFP program. And that you'll be on the high-medium caseload when you get out. You'll be required to do aftercare. I don't know how to stress strongly enough that this is your last chance. You will not, if you are back in here, I'm going to look at this paper and I'm going to wonder what I did and why. So you will be required to have a drug patch on at all times when you get out. If there's one positive, you're back in here and looking at that 10-year term. You've already agreed to 10 years. No negotiations, no whatever. This is it. You violate, you're getting the 10 years that you agreed to way back when. Do you understand? Yes.
Judge, the only question I have is, I think he was put on probation in 2016, wasn't he? Is that, can we extend for 3 years?
Well, he was put on a deferred in 2016,
Okay.
and then he was revoked and given a straight probation in
Okay.
2020. So actually, I could extend him for 5 more years
Got it.
instead of just 3.
Got it. Fair enough, Your Honor. Thank you.
I'm going to hand you the trial court certification. I need y'all's signature on that, showing that this was an agreement that I followed, and so you've waived your right to appeal. You'll go into custody. Obviously, Mr. Barrington will get it set up as quickly as possible for you to go take care of that other case down the hall in misdemeanor court, because until that's taken care of, you will not be able to go to safety. So y'all need to get that taken care of as quickly